Ghana is one of the most unproductive nations in the world. That's why our economy speaks for it. And we pay people, like President Kufuor said, we pretend to be paying people and they pretend to be working. That's precisely what it is. But what did our labor law say? The labor law says that don't pay anybody even a fadding, not even a peswa, not matching it with productivity. The law says so. Section 98, subsection G says so. Well, I'm quoting it because I happen to be the chairman of the committee that wrote it, so it's still in my brains. Let me tell you, if we implement the law, you as administrators, I guarantee you won't have the problem we are having in the country. We are paying people for appearing at the workplace, not because they are working. Somebody is busy working lotto, somebody is busy using 30 minutes on the phone speaking to the boyfriend. Or speaking about funeral, or speaking about wedding that is coming on. At that time, are you doing the business of the employer? What about the administrator? What are you doing at that time? Are we supervising people to do their job? Even private sectors are providing that kind of lazy, lackadaisical way of doing work in this country. Let alone public sector. It's a challenge, and we must move away from that. That's why we're talking about innovation. Again, Article 36, the Directive Principles of State Policy, clearly states that, let me read just 11, leave the 10. The state shall encourage the participation of workers in the decision-making process at the workplace. How do we get them involved? It's virtually nil, non-existing. Even though our labor law is very clear. Section 9, subsection G says that you, the employer, as a duty, you must keep channels of communication open. We don't. We close the door. So you get even people at the university go on strike regularly. The people teaching you, they are on strike. Even the custodians of the law, they are on strike. Everybody is misbehaving in the country. Unproductive nation. Oh yes, it's an unproductive nation. And I'm very sick. I'm 74. I'm very angry as I'm standing here. Because we have laws, we have educational institutions, and we are misbehaving in the country. We are unproductive. And administrators is a big challenge. Right after this conference, everybody your loins and let's get on and do the job that we are supposed to do. So as you will see on the screen, enhancing sound labor management cooperation, the law and the professional administrator. You see there, very clear, the power-based relationship that we used to have in this country is supposed not to be there. If we have what I read to you from the Directive Principles of State Policy on your fingertips, and we have the knowledge and the skill to apply them, not waiting for somebody. Clearly, we are not supposed to be operating on power-based. Everybody wants to undercut somebody, undermine somebody. You will not be productive as a nation. Under the labor law, section 1012 and 1034, and I challenge you, if you like, go to your workplace and see. When you're talking about standing negotiating committee or standing joint negotiating committee, public sector-wide negotiating committee, of course, as for them even, I help them to put down the draft of the rules. But a lot of even the private sectors, because I work for a lot of them as consultant, I can tell you that you don't even write the rules. And so in this institution, we must be able to bring to the attention of our students, our consultants, that according to the labor law, section 101, 2, and 1034, you must have new rules that will govern the procedure of every negotiation. And if you dovetail it into section 127, there cannot be even one single strike in this country because we are not doing the right thing. And I mean what I mean. There cannot be, because the labor law under section 127, 3, and 4 says that during the time of negotiation, the parties to the negotiation shall not even intimidate one another. You cannot even threaten one another. To threaten means you put on red band. That's the meaning. Oh, yes. To threaten somebody, you put on red band. You are telling me, are you seeing me? If you don't give me what I want, I will show you where power lies. That's what it means. But our university lecturers who are teaching you, they themselves even begin to go first before they come to the classroom. The red band is on their wrist before they come into the classroom. They are angry. The Attorney General's department, they are angry. They are on strike for weeks. They have to give them. So it's like you are intimidating the people to give you what you don't deserve. You don't know what we are doing in this country. We have the law. We are only talking about it. We have become parrots and always speaking about it and not acting upon it. Very shameful. We don't manage our differences also very well. I was with my uncle at Koforidua when we were doing the ADR Act, we were doing the winnowing. Almost all the people in the Supreme Court there, together with him, myself, late VCRAC club, all of them were there. But we don't apply them. Everybody is so legalistic. Administrators, you manage your differences. Managing differences is in various folds. Self-mediation is there between the two of you. You can resolve your differences so that you don't go into the court and have divorce certificates, husbands and wives, until we have about 520,000 divorces in this country. Very shameful. Very shameful. Sorry if you are here and you are caught up in that. That's your own matter. You see, I think that we must learn. And CEO, it's in your hands. Make sure, if you invite me, I will come. But you see, I'm very expensive.
No problem.
Yes, we'll try and do that part also. We must learn to manage our differences. And you, as administrators, you must learn the art and science of manager as a mediator. You have observed that two people, and I'll ask you a question very soon. If you pass, I'll give you some money. Now, if you have two people working under you, and the two of them have a problem that they are not communicating well, it will affect the flow of work. So you, as an administrator, must learn the art and science of managing differences between two people. And not waiting for the thing to escalate to a level that you have to go somewhere and look for Mr. Game. I'll charge you. Because I will help you to resolve it within 45 minutes, but you will have to pay for it. So learn it now. Interest-based. Our Labor Act don't have room for traditional collective bargaining process again. But we are still even having some collective bargaining agreement. I don't know where they are getting that from. It's an agreement, period. Bargaining is done in Makola when you want to buy shirt and they say 15 cedis, you reduce, ask for chain or arm if you reduce it from it. That's bargaining. But in a collective agreement process, we don't bargain because the labor law enjoins you to share relevant information. And you can't share information with somebody and then the person will now be demanding. And the only reason why we use the word relevant is because in salary administration, everybody's pay is personal to him or her. So you don't share pay with of people just anyhow. I know Ghana is a sickness. And you as administrators, you must ensure that that do not become part of the system again. It's the part, I'm quoting it from the law. The labor laws say in section 97 that you must share relevant information. And once you share information, let me give you an example. He is a married man. I'm sure you are married. Is that right? Does your wife know how much you earn? Are you sure? All right. If your wife knows how much you earn, why should your wife ask you more than you earn as chop money? Then your wife is not properly your wife. Because a wife is a part of the man. And if you are part of me and we share information, then you don't have to come to me and say, give me 10,000 cedis. When you know I'm earning 8,000 cedis, I should go and steal it from where? And that's exactly what is supposed to be done at the workplace. I've seen my brother who is in charge of the head of civil service here. The point is that fortunately for us, as public service, We even have an open budget system. So sharing information is not difficult. We work as consultants to a number of companies, very prestigious ones as such. And I can tell you that we compel the employers, even in private sector, to share all detailed information. Therefore, we don't have strike in the companies that we work for. And it won't happen. Not under my watch. So clearly, as administrators, you have a challenge to ensure that you have sufficient, not just adequate, sufficient knowledge about the Labor Act, about the ADR Act, and about the Social Security Act, about all laws that pertain to your work, and you must know how to apply them. And let's take away the legalistic aspect of it. If somebody is criminal, go to my uncle's chamber. He will go and lead you and deal with the criminal aspect of it. But civil-like matters, that's how it's supposed to be. In the U.S., where I did a lot of my studies, also in the ADR, I can tell you that about 60 to 80% of virtually all civil type of cases are handled through ADR. In Ghana here, everybody, you want to show where power lies. You want your day in court. Go there. You will charge you. And you can't pay. It's a very expensive person too. Now the labor law enjoins all of you as administrators to ensure that if you read section 11 of the Labor Act, it says that you must ensure that the people who come to work at your place work conscientiously in the lawfully chosen occupation. You didn't force anybody to work. Therefore, when people come to work, they must work conscientiously. Very important. And they must report for work regularly and punctually. Do we do that in Ghana here? The law says in section 11C that you as a worker, it is your duty to enhance the productivity of the employer. Do we enhance productivity? We don't even allow people to have ensure that the board of directors have approved that this is going to be what we'll be doing in the year 2024. By November this year, you must make sure that you set in motion that people will have what they are supposed to do. KPIs, so that you appraise them properly and you match the remuneration. Remuneration is the total cost, not just pay. Total cost. So you match the remuneration with productivity. Section 98G says so. Zero. So say we have to change the pattern of our learning. And a new way of conversation, having a conversation, not argument, not debate. If you argue, somebody will win, somebody will lose. If you debate, somebody will lose, somebody will win. Have a simple conversation. Simply means having the quality of the relationship between two of you as you engage. It defines the quality of the relationship between the two of you. How can you be arguing with your husband? It's not possible. Your colleague worker, you are arguing, instead of you to have a brainstorming, simple brainstorming session. And then you agree, you have options. Options is plural. If it's singular, then it's position. If you take position, I take position. Nobody wins. So I think that it's important that these simple things that are very, as if they are so old, they are the newest thing. They're the newest thing. And I think it's important that because of time, I have a lot of slides I would love to show you, but because of time, I just go, come and meet you somewhere. Let me deal with this to help you appreciate this. We call it cycles of perception. Perception today, if I were to be preaching, I would call it a demonic thing. Because if you perceive me that I am like this, what else can I do? Because that is what you have perceived me to be. But there must be a way for the administrator to resolve such differences. That's what we call it the yellow zone. It's a jaundiced kind of behavior, a dissonance character. He is perceiving everybody to be something and he is not. So, perception in the yellow zone. Then you have the red zone where you have fight, flight, freeze. And this operates second by second everywhere across the entire globe, the entire world. Second by second. Everybody is either operating in the red zone the yellow zone or the green zone. I'm bringing it to attention, and it's very critical. There's a trigger. A trigger is like, I've said something, and he is unhappy about it, or she is unhappy about it, and so she is reacting. And Ghana here, one of the things we are very good at doing is to react. Instead of having to take it easy and ensure that we engage in a conversation which defines the kind of relationship that we have and resolve the differences. Instead of operating, fight is like shouting, screaming, or throwing blow, or shooting somebody, or pouring acid on somebody, like the men used to do to the women in particular. That kind of attitude. At the workplace, let's focus at the workplace. Let's focus on our country. Fight or flight, to walk away from a meeting, bang the door, and walk away. I will not participate in the meeting again because the chairman of the meeting says something you don't like. Or otherwise, someone step on you, there's a trigger, and so you perceive that they are against you, and so therefore you walk away from the meeting. Or you freeze, which is a very common denominator, hence the plenty divorces in Ghana. Freeze. The women, very common. Small thing, she's angry. I won't talk again. Are you coming back to the house? If you come back, then stay and resolve the matter. And you, the men, to stop beating your wives. Because that is a very lazy way of doing things. An incorrigible man is the one that lifts his hand to beat the wife. An incorrigible administrator is the one that cannot talk to two people working under you to resolve your differences, and it escalates until you are looking for somebody to come and intervene. Washing your dirty linen in public. So that's how they operate in the red zone. And it's minute by minute. As you are speaking, there are people in your workplace now, they don't talk to one another. You know them already. Don't mention their names. There are plenty people. People even die without talking to people. Where you meet your God, it's up to you. So, green zone is where we must dwell. Release the information. Let me just tell you that these were the things I've known already. And so, as chairman of the committee that was drafting the Labor Act, I introduced my colleagues to it. We went to where I studied part of it. We wrote this law. It took 4 years to write the Labor Act. And it passed through virtually 2 regimes. The present president, Nana Akufo-Addo, was Attorney General. When we had completed the writing of the law, we got all the memos ready to be sent to Parliament. I said I was not going to stand election again. All the rest jumped into the Bush campaigning, so we couldn't pass the law. Then NDC lost election. President Kufuor came to office, and he became the Attorney General. And he's my friend. We share a common name. My middle name is Akufo, and his is, I used to tell him, his is the old one, mine is the new one. So we met in his office for 4 hours, went through the labor law again. So he represented it back to cabinet. He brought the ILO people, we did the further winnowing and submitted to Parliament. I helped them to pass it through. Now, so I'm just trying to tell you that this thing you are seeing here informed us to write Section 97. But when we release information to the social partners at table, long before the negotiation, everybody is seized with the same thing. So we cease to be on different tangents. We are all on the same page. We all have ownership of the same information. So why are you going to ask me, I want 50%, then we come to 30%, then we come to 25%. What kind of macula trading is that? We don't do that in workplace. So when I hear they are negotiating and the union have submitted a proposal of this, management have submitted, I say, these people, they haven't even come to the market yet. Whether it's government, whether it's the university, whether it is this, I don't care. We are doing the wrong thing. We must change. We must be agents of change. You, the administrators, it begins with you now. If you release the information, everybody relax. Our relationship becomes stronger. And nobody loses. We all gain. It's both gain. I believe in using the ghost principles. And there's just People believe in ghosts. I don't believe in ghosts. If you believe in it, carry on. But I use it as an acronym. We have to, as administrators, you must learn the art and science of planting in your soul, in your heart, in your body, visibly, you must be gentle. And gentility is not about wearing this kind of dress. So there are some bavus in Ashama that wear this also. But you must be gentle in your spirit, and you must act it out at the workplace. Let the people follow you. Be an example. Honesty is not negotiable. I know in Ghana here, dishonesty is all over the place. But we must be honest, especially you as administrators. We must be honest. It's a cardinal call. And we must have an open channel of communication. Be open. Be open. Be visible. Nobody will accuse you. Be visible. You lose nothing. You gain. And our meetings must be very specific. Our agenda must be specific, well tailored to the issues we want to deal with. And let's talk about it. No talking, no solution. No talking, no solution. What you will get is chaos. And I pause here to ask you a question. Sir, with due respect to all of you. So, question. If you know it, lift up your hand. If you don't know, doesn't matter. I will not accuse you. Who pays your monthly pay? At the end of the month of July, everybody will be paid. Now, question. Administrators, who pays your monthly pay? Those from Ghana and Ghana, don't lift your hand because I've taught you, so you know it. Now, so, yes, you, if you don't answer it, I will let you pay some money right here for everybody to see. You, because I know you. Madam, yes, you know it. Yes, who else? Who pays your monthly pay? I want to see your hand. If you know it, it's good you have not lifted your hands. But if you make mistake and I call you, you can't answer, there will be trouble here. Say, Chairman, Madam Chair, I'm glad you are in, and God richly bless you. Listen, the reason why I've raised this question is because in my study in Japan, I realized that we have a problem. And the problem is that we don't even know who pays our monthly pay, so we misbehave towards the people who really pay our monthly pay. You know what it is? I will not ask you again. I will give you the answer. Our customers pay our monthly pay, not the president of Ghana. The president himself is a worker. Now, the head of civil service is not the one who pays your monthly pay. It's not the controller and accountant general. It's not the CEO sitting here. You are paid by the customers. So if you go on strike and you are in a service sector that you have competition, you must expect your customers to go to your rivals and buy the same service and buy the same goods. And I was telling the University of Cape Coast people, they must revise their teaching notes. It's very critical. We must change our attitude towards what we teach and what we practice. Our monthly pay is paid by our customers. Therefore, you can't be on strike and expect to be paid because the money is generated from the customers. We must know that. The labor law says so. And that's the spirit in which we wrote the labor law. So if you come to meeting, time is money. Wasted time means money wasted. You must learn these things and be thorough in them. As you see here, quality and productive workforce. Duty imposed by law and the administrator. By what you see here, in the yellow zone here, high quality professional administrator. That's who you are. You are the people who manage the people. You are people managers. Computers don't talk. If we have problem with them, we'll deal with them by repairing them. But what it is that, please come and help so that they can see the projection. Okay, maybe it's coming back. Yes, that's okay. People. Then policy and strategy It's our board that would develop, but you, the administrators, supply the information, the technical information. The board sits and come out with policies and strategies, and then we are asked to implement them, and then you carve out the one that each and every one as a KPI. The law says in section 8, so section B, section 8, it says this is the authority of the employer, the rights of the employer is to ensure that you write policies, programs, and set targets. In Ghana, we are not supposed to go to work and do what pleases you. And I'm not talking about appointment letters. I'm talking about annually, there must be targets for you to achieve at the end of the year. So every half yearly or every quarter, there is a performance continuous evaluation going on, so that we don't pay you because you appear at the workplace. And because, excuse my language, the most silly thing we do is that we pay across the board. Lazy workers, average workers, high flyers are all paid the same 20% across the board. Very lazy way of managing people. So please, administrators, I challenge you, after this conference, I'll be looking around your windows to see whether you are still doing the same thing. Yeah. So I challenge you, we must make sure that our leaders get the policies well written, and then labor management cooperation must be in place to ensure that they benefit from it. Then the processes, how we do the work. And as you see here, the results is that we are all stakeholders. Stakeholders are people or groups who are interested in the success story of any organization. Ghanaians, we must learn to be interested in our country and ensure that we contribute to the growth and development of the nation. Then we can have a share in it. And remember, it's customers that pay our monthly pay. And the outcomes must be visible for all to see. I think I'll pause here for the sake of time. And another time, I'll be able to get along with you again. God richly bless you, and thank you.
Thank you so much, Mr. Game. Let's do it better for Mr. Austin Akufo-Game. Ladies and gentlemen, in the course of our presentation, we were privileged to have our chairperson for today's occasion in our midst. Our chairperson for today is the first female vice chancellor at the University of Ghana. She's an experienced academic and university administrator with more than 20 years of experience in the higher education sector. She brings a lot of innovation, resourcefulness, and tact to her professional engagement. Ladies and gentlemen, our chairperson has acquired extensive multicultural experience through various professional engagements in 20 countries in Africa, Europe, Asia, North America, and Australia. These engagements include giving competitive and invited talks, serving as external assessor, engaging with research and professional collaborators. She is an engaged public speaker and has been featured on several local and international media platforms. Our chairperson for today has a professional expertise and leadership and has been recognized by her peers. She serves on the consultation board of the International Pragmatics Association. The first African to be so elected since the association's establishment in 1986. Ladies and gentlemen, if I would continue to give you the credentials of our chairperson today, we won't end today. But you are privileged to have very much details in the brochure you have with you, so you can read more about our chairperson. With a round of applause, kindly help me welcome Professor Nana Aba Apia Amfo. Let's do it better for our chairperson. Before I hand over to our chairperson, car number GE807-11 Honda. Please, you are needed outside. Car number GE807-11. Thank you.
Thank you, Madam MC, for that eloquent introduction. The chairman of the Board of Trustees of the Chartered Institute of Administrators and Management Consultants, Ehuna Bubrim. Sorry, I don't have slides. Yeah. Ehuna Bubrim, Pra Ajinsiem the fourth. Oh, sorry, the sixth. Sorry. The board members of CI, MC, and partner institutions here present, fellows and senior members of CI, MC, and partner institutions, our distinguished guest speakers, we already heard one, heads of educational and professional institutions here present. I see that's Esther Faye Abuaji, right? Thank you. I acknowledge your presence. Representative of partner institutions constituting the conference planning committee, the media and participants of this conference, ladies and gentlemen, good morning to you all. And oh, I know breakfast. Good morning. Yes, please accept my apologies for running late. It is not out of disrespect or disregard for this group. When I accepted to do this, and then there was a change in date, and as some of you may know, my calendar fills up quite quickly, so I've had to handle 2 engagements before getting here this morning, but I'm glad to be in your midst this morning, and I feel honored to be invited to chair the 2023 edition of the Chartered Institute of Administrators and Management Accountants, Ghana. Sorry, consultants is. This, I understand this is an annual conference. I don't know how many years it's been running, but I know it's a 5th year. Thank you. And as an administrator of the only university in Ghana, and I see a number of my administrators here, I cherish this opportunity to meet with colleagues from other educational and professional institutions to discuss and share. Who is interrupting me? I'm the chair. Whoever it is doesn't have the permission to be speaking. Well, I speak. So I cherish, was it myself? Oh, I see. It didn't sound like my voice. So anyway, technical people, I hope you can sort that out. So I cherish this opportunity to meet with colleagues from other educational and professional institutions to discuss and share ideas on matters of common interest pertaining to our professional growth and development. Though we recognize the important role played by administrators and other professionals within the work environment, often there are not enough learning opportunities for us to take advantage of and sharpen our skills and keep abreast of contemporary and best practices across the globe. When opportunities such as these become available, we are inundated with meeting deadlines that we are sometimes not able to take advantage of. What we don't recognize is that these are opportunities for us to learn more, to renew ourselves, and be more efficient and effective with what we do, so that we are not just being paid for showing up at work, but we are actually being paid for the work that we do. So I must applaud all of you participants for taking time off to come here to learn, refresh your minds, and more importantly, make new contacts or strengthen existing ones to improve your overall effectiveness, efficiency, and productivity. I wish therefore to applaud CIAMC for sustaining this annual conference, which is now in its 5th year. The Institute is obviously living its vision of advancing and ensuring professionalism in the practice of administration and management consultancy through certification and learning. I also commend the Conference Planning Committee for assembling some of the best brains to discuss critical legal issues for effective administration. We've already heard Mr. Austin Game, my very revered friend, Mr. Sam Okujeto, is also on standby to deliver, and I can't wait to hear and learn more from him. Now, in the performance of our duties, administrators and managers make several decisions daily, and we are expected to generate workable options and select the most appropriate course of action for various tasks. The administrator is therefore expected to execute their work within the confines of the law so that we minimize arbitrariness. It is often said that when you are caught on the wrong side of law, then you will know the law exists. So for this reason, it is important for all of us to acquaint ourselves with some legal rudiments, knowledge of law, which is not just meant for lawyers, but also to enable us to do our work efficiently and within the confines of the law. So for today's session, we are privileged to have some legal luminaries to educate and inform us of the critical issues we must not take for granted in the performance of our functions as professional administrators. Now, I must indicate that the carefully selected speakers do not only possess the needed legal background, but also have a rich blend of administrative experience to bring a practical and relatable dimension to the discussion. So we are not here just for book-long lectures. We have people who will speak also from their personal experience, and we already heard Mr. Austin Game do exactly that. I look forward to some very insightful and thought-provoking discussions and hope that participants will be equipped with knowledge to make coherent and legally sound decisions as administrators and managers. Indeed, I'm here as chair, but I'm also here to learn. So, ladies and gentlemen, on this note, I humbly accept to chair the 5th annual CIMC Admin Professional Conference. Thank you.
Ladies and gentlemen, let's appreciate our chairperson better. So before our chairperson gave us her remarks, Mr. Game entreated us as administrators and management consultants to act as managers who are mediators as well, to have discussions, not arguments. And then the green zone, the perception, the cycles of perception. We have the red zone, the yellow zone. He entreated us to always try to be within the green zone. And also, as administrators, we must be agents of change. At this juncture, we would zoom in straight to our second speaker. Our second speaker is a legal and property consultant, a child online protection expert, a women's rights advocate. She was an adjunct lecturer and team lead for conveyancing and drafting course at the Ghana School of Law for 10 years. She has vast experience in the civil society space, where she has advocated for laws and policies to promote the rights of women and children. Ladies and gentlemen, she is an alumna of University of Georgia School of Law, USA, Ghana School of Law, and University of Ghana, Legon. She has a master's degree in international business law and certificate in international human rights and cybersecurity. Our resource person is a court-appointed special advocate in the state of Georgia, USA. She's also a trainer of trainers and has facilitated several workshops and seminars. She also has presented papers at local and international fora like the African Union, World Bank, and United Nations agencies. Ladies and gentlemen, it is a tall list. Our resource person is currently chairing the Board of Women in Law and Development in Africa, WILDAV, Ghana, and WILDAV West Africa, Lube. She is a member of the National Domestic Violence Management Board and FIDA International Board, and an election observer for ECOWAS, that is the Economic Community of West African States, and the African Union. Ladies and gentlemen, with a round of applause, help me welcome Miss Efua Brown Eisen Esquire. We can give her a final applause as she mounts the podium.
Thank you very much, Madam Chair, Nana Chair, my lecturer, Mr. Kujetu. Please let me stand on the existing protocols. You can't but acknowledge your lecturer, and it's pressure, but all is well. So thank you so much, CEO, for inviting me to this August meeting. It's a very broad subject, but we've tried to make it in 30 minutes as I was allocated. So the title is Landed Property Procurement, which is a whole subject on its own, contract negotiation and conveyance. So we look at the outline, which is procurement methods for land acquisition, interest in land, who can own lands, due diligence, contract negotiation, conveyance, and registration. So I understand most of us are government workers and some in the private sector, but for those in government, any procurement that has funds wholly or partly public funds would have to go through the Public Procurement Authority. That's the Public Procurement Act. The amended one is Act 914. Although there are different ways of procuring, for most people, they just decide on their own, individuals, to just buy land, some informally, without any paperwork. Some would also go through the formal process by even getting a lawyer to assist. Most companies would also have laid down procurement procedures in also handling their acquisitions. But for government, it will be the Public Procurement Act, and the focus of the act is to ensure that there's value for money. So for procuring under the Public Procurement Act, there should be a management decision. And as we know, most managements exist before the board. So management will decide if the board is constituted, they would now approve. Then there should be a procurement plan which the acquisition of this landed property would be included in. Then there should be a decision on which procurement method is going to be used. Is it going to be national competitive tendering? Is it going to be restrictive tendering? Is it going to be sole sourcing? These are decisions that should be made by the board or management, and the procedures are different. If it has to be single sourcing or restrictive tendering, then that means it has to go to the Public Procurement Authority for approval. There are also other approvals in the Public Procurement Act. But if one doesn't go through that, then you have to meet the committee, PAC, Public Accounts Committee, where you would have to answer why you didn't follow what you had to follow. So, what are the interests in land currently? I'm sorry, the slides are, the writing is not quite legible. But we have the allodial title, the common law freehold, customary law freehold, usufructuary interest, leasehold interest, and customary tenancy. I know it's a lot of things that you wouldn't generally be interested in, but just bear with me. So all that we are saying is that there are different interests in land, and one should know what they are going in for. So and that would also mean how to negotiate. So let me just go to the first one, the allodial title. We are not going to make this academic, so please bear with me. So allodial title is the highest or ultimate interest in land. It's often owned by the states, a stool, skin, clan, or individual. So we hear that, oh, this area is Osu land. Please, you've heard that before. And this one is La land. So they are the allodial holders of that area. So we can have, let's say, this area, I'm not too sure where it falls under, but I know some parts of it would fall under Teshila and things like that. So although there might be an individual here, the allodial owner would be that particular stool or family. Also, families can also be allodial holders. A clan, a skin, when you go to the northern parts of the country. And the states, this didn't used to be the case in the previous law, but now the law says that the state is also an allodial owner. That means when they compulsorily acquire the allodial interest of a family or a stool, they now become the allodial interest holders of the land. And that would mean that the families cannot now hold them to ransom that, okay, you didn't hold this, you didn't use the land as you asked us to, so now the land reverts to us. They are now the allodial holders of the land that are compulsorily acquired. And most often, this happens, I just talked about compulsory acquisition, conquest, pioneer discovery, settlements, gifts, purchase, or agreements. So this is how the allodial interest is acquired. But out of this allodial interest, we get the freehold and the leasehold. And in most situations, administrators would be going for either one of them. Although there are some constitutional restrictions as to freehold now, because in our 1992 constitution, stool lands cannot grant freehold interests. And when we say freehold interest, we mean that absolute interest, no time limitation. So when you are going for a lease, they'll say, 99 years. We know about the 99-year lease. And most people assume that lands acquired by lease are 99 years. It's not so. Some are 50, some are less, some are more. But let's say the highest is 99. So if you don't really make your inquiries, you might buy property. And when I say buy, it's in quotes because you don't really actually buy leaseholds. You might acquire property thinking that you have a long term, and it's not so. So out of the allodial interest, you can get freehold where you have unlimited time or unlimited use of that land, and leasehold, which is limited. So the difference is that one is absolute, one is carved out of the allodial interest, and other interests, as I mentioned earlier, are the common law freehold, customary freehold, usufruct. I'm not going into all that because of time constraints. Then there's perpetual duration for freehold, but for lease a certain term. So when we say that 99 years, we are certain. 99 years starting from, let's say, 1st May, whatever year, ending on 30th April in 99 years later. Certain. So there's no confusion about these leases. For the freehold is subject to state and cultural rights of the allodial holder. So although one has freehold, when, let's say, depending on where you are, the original allodial holders claim that, oh, you have to come and support us in our festival and things. You cannot say, oh, because I have a freehold, I won't mind you. You know, the system is still, interlinked. So you still have to attend to these requests from time to time. But for the leasehold, it's specific, often contractual, not often. It's actually contractual. So the terms are there. Unlike the freehold, once you acquire it, you don't account to anybody except these cultural obligations in quotes. But for leases, there are specific terms and conditions and stipulations that once breached can even terminate the lease. So for freehold, it's free from obligations to anybody. But for the leasehold, there are also smaller interests that can be carved. Actually, the lease is said to be one of the best innovations ever in land law, because one can have a lease, one person can have a lease and create different interests. You can have a sublease, like if you have a 99-year lease, you can have a, let's say, 20-year sublease to, let me do it this way. I am Mr. A, I'm Mrs. A. Mrs. A now grants a 20-year sublease to Mr. A, Mrs. B. It's easier that way. So now we start with 79. After the 79 years, it comes back to me. Then I can agree again to do another sublease for maybe another 50 years. At the end of the 50 years, it would come back to me again. Then later I decide, okay, I'm tired of this land, I'll do assignments. That one, I'm just clearing everything to the grantee. And that one, it won't come back to me again, but it will go back to the allodial holder. So once you have a lease with a considerable length of time, you can do a lot with that. Same with the freehold. You can also carve leases out of a freehold, carve minor interests like subleases, assignments, and even tenancy agreements. So the constitutional restrictions for leaseholds is that for foreigners, one cannot give them more than 50 years. Although we see it around, it happens a lot. They just assign whatever interest they have, which is often more than 50 years, to foreigners, and they are enjoying to the detriment of the local owners. So, Section 67 of the Land Act 2020 defines good title as one derived from an enactment, a grant, vesting order, or conveyance from the state, final judgment of a court or competent jurisdiction, or a grant, acquisition under customary law, conveyance, assignment, which is at least 30 years old. So all that we are trying to say is this. Once a law, when you say an enactment is a law, once a law is granting you a parcel of land, it's good title. You don't have to overwork yourself in trying to find out how did this one get this, check the root of title and all that. Then once it's from the state, it's even easier. Although we also know that states are also struggling with some families and stools over lands. Then final judgment of a court of competent jurisdiction. This can be tricky because you might think it's final, but it's not final for somebody. So once the Supreme Court is good, but once you have maybe a high court judgment, one cannot just accept that ends the litigation. Then once it's more than 30 years, the law considers it as good title. So what is conveyancing? Conveyancing is basically investigating the title and preparing the necessary documents to create an interest in land. So what do we mean by investigation of title? one has to do their due diligence in acquiring, most especially in Accra. One cannot take it for granted that, oh, I'm going to acquire property, so I'm just going to get a lawyer to do the paperwork. No. You would be buying litigation. So what is the conveyancing process? The pre-contract stage is where you do the inquiries, the due diligence, the searches, and after that, the contract negotiation would start, then the exchange of contracts. Then pre-completion is, so let me go to completion before pre-completion so that you understand. Completion is when you finish, when the property is transferred. So before the property is transferred, there might be things that one might want, like, oh, I want the land registered. Maybe there were some paperwork which wasn't done earlier, and in the next slides I'll be talking about some of those things. Then the post-completion will be registration. That's after the property has been transferred, you decide to register. Actually, it's mandatory to register, but the statistics are very, very low regarding land registration in Ghana. But one thing we all have to be careful of is fraudsters. This sector is is overrun by fraudsters, and one can't take anything for granted when acquiring property in Ghana. But before we look at the paperwork, let's consider this one, possession. Most people think that once they have their documents registered or their land registered, they have a better title than those who are originally or have been on the land for several years. Possession is also good title. And in this case, it was a Supreme Court case, Western Hardwood Enterprise Limited versus West Africa Enterprises Limited. The court held that possession is seen as a source of good or reliable title to land against the whole world except someone having a better legal right to possession. And there have been a few cases in the Supreme Court where people who had land title certificates, where the court held that the land title certificate was given to them by mistake or fraud because they knew that people had a better title on that land or people were in possession. And this means that customary way of transacting, with regards to property, is valid, although not written. Because most people, and I believe that even if you go to our rural areas, most of them would have lands which have been owned by their families for a very long time, and there's no document, not even a site plan. And yet, everybody knows that this is Openi Kojo's land. Everybody knows whose land it is. And that would mean that it cannot change just because we have a registration regime. So the law appreciates possession as well as registration of interest. So when we want to investigate title or do our due diligence, what do we look out for? We have to verify the identity of the vendor. This is a major one. Major one. Because now there are a lot of real estate agents, but this one, I'm even talking about the one on the internet. You know, they have Tonaton, they have all kinds of places where you can go, you see the land, you like it, then you start, because most of the time you will see some of them online. And you never see the person. But you get a phone number, you call, you meet somebody who claims to own that interest in that property. How do you verify you are dealing with the right person? A lot of people have thrown money away. Some millions. And this means that we cannot take land acquisition lightly. Even rents. There have been several cases where even rents, which is not so much, people will just come, pretend they are the owners, and just take people's money. So verifying the identity of the vendor is critical. How do you find out? That means you have to go beyond the norm of, oh, let me see your ID card. Because everybody has an ID card. The fact that we did national identification card even shows that the ID card is not working. And even with that, we've started hearing stories that people have been registered with that card, in multiple ways. So that means one has to go beyond just the ID, get to know a bit. And it's difficult now because, previously we knew each other. We were quite close. We had more of a communal lifestyle. But now it's more individual. So even trying to investigate somebody is difficult because you just hear that, oh, he just came to live here yesterday. And he's now selling his property. How would you even find out? Sometimes the police must come in if the stakes are high. Then the vendor's duty to prove title. After you verify the identity of the vendor now has to prove that he owns the property. He's saying that he owns it, but how does he prove it? With the necessary documentation. If there's no documentation, then the necessary evidence that shows that he or she is the owner. Then now, the administrator might have to find a lawyer, or he or she must evaluate the documents of ownership. It's advisable to get a lawyer for some of these things. So you have to evaluate the documents of ownership to see whether there are any gaps. Because one can go through the process only to find out that the person is not the rightful owner. Conduct searches at Lands Commission. I've had an experience where I went to Lands Commission. Sorry I'm saying this. But I had 3 searches over 1 parcel of land. 3 different searches. Because sometimes there are also some scrupulous people there who do all kinds of things. So even Lands Commission search, go further. What I understand is that if you go through the survey, if you do a search at the survey, the deeds registry, and the land title, you get a better view of how things really run there. Then town and country planning, is the area even zoned for that purpose? You want residential, yet this place is commercial. How can you go and build a 4-bedroom house at Makola? It cannot work. And a lot of people are just buying things or buying property where the area is not zoned for that reason. Another area is the collateral registry. If the land has been mortgaged and the person is not paying, and sometimes that's the best time to sell, so that now you'll be laden with that burden. One has to look at the collateral registry or the Registrar General's. Now the name has changed, but you know what I mean. Yes. Then site visits. This one, you cannot overlook it. After you've looked at the documents and he or she has convinced you that they are the real owners, you have to go on the land. Because sometimes that's the determining factor. Is it what you even want? Because sometimes the house will look so nice on the screen. You go there, maybe it was like that 50 years ago, and the picture is still there. So one has to go to the site, talk to people. I remember I was investigating a particular property for a client. This person said he was selling the property for quite a huge amount of money. And he was a prince, and my client was not a Ghanaian. And he kept on saying he was a prince, and the people, he's doing this for his people. And I realized that my client was calling him Your Royal Highness. I said, oh, this one is not a Nigerian movie, it's not possible. It cannot be Ghana. So immediately my red flags went up. Because why would you be trying so hard to show somebody that you own something? Then we went on the land. He showed them the land. This was his. It was near a railway. He said even one can go near the railway because the railway is not working anymore, blah, blah, blah. Anyway, after that, he gave us the documents. We started looking at the documents. 4 different documents, 4 different names. And he said it was his. But I still knew I had to talk to people there. The first time I went there, they said, oh, it's for Prince, it's for him, blah, blah, blah. Okay. So later, I talked to the people around, the neighboring areas, talked to people around, only to hear that the land is owned by Prudential Bank. And even at that time, that land was even in courts. So, you just have to go there. Because sometimes you get to know that the person is not even, and the person actually had people on the land fronting for him. Because when you go on the land, everything looks okay. But there was something not right because of the documents he gave. Then litigation is the biggest issue. Lots of land are in courts, and yet it's difficult to determine which one. Because we don't have a one-stop shop place where you can just click your computer and you find that, oh, this land is in courts. How would you even know the title of the case? So, once again, one has to be very careful, but when you talk to people, you see, the neighbors always know a bit more than the others. So when you talk to people, and that would mean that if you are talking to these people, you have to be nice. If you go there thinking you are the owner, you are going to buy, you are looking pompous, they won't mind you. And yet they know more than you. So you have to have a strategy, going to the land, being nice, and then you get the information. Then maybe the quickest way is going into occupation, throwing land, soil, stones, do a brick wall. If nobody breaks the brick wall, then that means you are in luck. So for contract negotiation, what would we look out for? Sometimes the documents are in error. Sometimes the years are less. Recently, somebody I know very well bought land for about 20 years, and he thought he had 99 years. I know about 19 and 17 years, and they believed they had 99 years. The thing is, if they knew at the time of sale, they could have negotiated for a lower fee, a lower price, if they really wanted that property. But most of the time, they get to know too late, and there's nothing to do about it. Then the state of the property. If the state of the property is bad, you can also negotiate for a lower price. Sometimes the person said, oh, it's registered, but what is registered is the documents. We have the deeds registration and the land title registration. So the title registration is what is a better registration, but sometimes they can say, oh, it's registered, so you can say, okay, because the land isn't registered as you told me, be down the price because I'm now going to do this and that and that. So for contract negotiation, once you see things that do not add up, it's a good opportunity to negotiate for a lower price. If you don't want it, so fine, you can leave it. So another area we have to consider is inherited property. Have we even seen the will before going for this property? Is the person we are going for the property from, is the person's name in the will if the person died in the state? And one thing is that once a will is drawn up, the person dies, the person is in debt. It doesn't mean that the fact that your name is there, that you are going to inherit this property will happen. they have to pay all the just debts first. So one's name can be on the will and yet will get nothing. So one has to be also do some due diligence, get to know a bit more about the family before they pay any money to anybody. Then there's also a section in the Wills Act, section 13, which deals with reasonable provision, where the court will decide that if the person who died, the testator or testatrix, during his or her lifetime didn't make adequate provision for a child under the age of 18, a spouse, a dependent, then within 3 years after probate is granted, the person who is aggrieved can go to courts for reasonable provision to be made for them. Most of the time, they'll go for cash, if there's cash, because they wouldn't want to disturb the dead person's wish. But I've also handled a few cases where property, which were given to some people, were rather given to children who were not catered for in the will. So all that I'm saying is that somebody's name might be in the will, but it's not automatic that they might benefit. And it's important that we do our due diligence. Letters of administration should be checked and see who the administrators are. A little trick on the letters of administration, you know, and even wills, you know that the law says that even if the deceased considered someone as a child and the person is not a biological child, the person can also benefit. I think it's an area we have to all look at it again. However, this could create serious issues. So once again, maybe the man can say, it's going to my children, and somebody says, oh, he considered me as a child. He even named me, he took care of me, and I am a child, and can contest with that. Letters of administration and probate, the difference is letters of administration is granted to those who die intestate without making a will. And this is the authority document one can use to distribute the estate of the deceased. And the probate is the other for the person who died testate, the person who died making a will. So the will. The probate is now given to distribute the property. So that means one cannot distribute property without these documents. And once these documents are granted and the administrators or executors distribute the property, then there's a vesting assent. This vesting assent is what transfers the property to the beneficiary. And that would mean that if one is going for an inherited property, you need to see all these documents before you should even decide that this is something we are considering getting. A thorny issue is consent of beneficiaries. If the property is going to children, and we know our polygamous nature in Ghana, there are about, let's say, 11 children. 2 from the latest matrimonial home, 3 from the previous marriage, 2 side chicks, 4, things like that. So now it creates an issue. How can we all decide that we are selling the property? Some can just be difficult. They want to sell. But just to show you that your mother took over my father in 1966, they won't sell. And the issue is sometimes they can get sides, and once you get into that procurement process, it just becomes war, unnecessary warfare. So you shouldn't even go near. Think when you see consents, sometimes it's not even that 11, it's just 2. And there's no agreements. It's also a problem. Then one has to also know when occupants are vacating. Sometimes the property is sold and yet people don't want to leave. Even Sodom and Gomorrah, remember they took government to court. So we can all learn lessons from that. So that means private property, they can do all kinds of things. And we need to ensure that the place is free before we decide to go for the property. So the Land Act has some interest in the new Land Act. It's a recent one in 2020. It has some interesting provisions. And now it makes it criminal for anybody who is holding property as a fiduciary, using it for his or her own purpose. And it's liable upon summary conviction to a fine of 60,000 Ghana cedis to 120,000 Ghana cedis, or a term of 5 to 10 years, or both. So you know that when you are buying landed property, okay, so for stool families, clans, they are communal properties. Most of the time headed by a chief, a family head, or a tendana, or something like that. Or a tendana, yeah. So once we have these heads, most often they behave as if the property is theirs, instead of holding it in trust for their stool or family or whichever. So we have to also ensure that we have the consent, we see the consent of the family members or elders of the stool, because they can also set a sale aside. But now it's a criminal offense if they act as if the property were theirs. Another interesting one is land guards. It's been a terrible issue for most people, where even when, before you even dig your land, people show up to demand their portion before you can build. Sometimes they have no claim, nothing close to, they just come to harass you. So now the law says that anybody who unlawfully uses force or violence to prevent a person who has an interest in land from having access to the land, or drives away that person with an interest in land from the land, commits an offense and is liable on summary conviction to a term of imprisonment for not less than 5 years. Then where there is use of violence, intimidation, obstruction of a lawful owner from the land to develop their land, it also attracts not less than 10 years imprisonment. But one thing is, now one can get a restraining order against any person who unlawfully exercises or purports to exercise supervision or control of the land. This is also novel. So instead of the usual injunction, one can also go for a restraining order. The law says in section 33 that it's a lawyer who should prepare a conveyance. And when we are preparing conveyance, it has to be in writing to be enforceable. Signed by, when it has to go to court, a contract for transfer of an interest in land is not enforceable if the contract is not evidenced in writing, signed by the person against whom the contract is to be proved, a person or somebody authorized. So if one person, let's say I purchase a freehold and I'm not available to sign, somebody can sign on my behalf, but that would mean it would require 2 witnesses. But if the person is signing, it would require 1 witness. When we do contract for sale, it is not the transfer document or the conveyance itself. So the conveyance itself will be the lease document. But most of the time there could be a contract, some people call it hire purchase agreement. So that one will spell out the terms that should be in the contract. There might be milestones. Let's say if the person is trying to get a land title, we'll say that, okay, once you get to this stage, you pay me 20%. Once you get to, or even if, let's use the inherited property. They've not gone for probate, but you know that it's for them. And you really want it because you think it's hot cake. Okay, But for government, I wouldn't advise. But for individuals, if you want to take that risk, you can say that once you get the probates or letters of administration, I pay 20% of the money. Then after I get this, I pay another. So the money can be spread out within a year. And most often, if you want things done, you don't pay everything in bulk. Otherwise, you won't get what you want. So you stretch it out to ensure that whatever your requests are fulfilled. Still in the same Land Act, there are also interesting provisions regarding spousal property. So now, it didn't used to be the case, but now one cannot sell, exchange, transfer, mortgage, or sell land, right or interest in land, or enter into a contract for the sale, exchange, transfer, mortgage, or give away land without the written consent of the other spouse. So once is matrimonial or marital property, just as we talked about consent for beneficiaries, this one too, consent is required. In time past, our dear men would say, oh, I'm doing it for the family, I'm doing it for the family. The court says you've done enough for the family. Now, we want to see it in writing. This is good news for some people and bad news for some people, but let's all be mindful of that. That once the property is owned, and now actually the law is saying that if it's acquired during the subsistence of the family, it's matrimonial property. It is now addressing the issue of Article 22 of the Constitution, which had been dragging for a very long time. And that ends my presentation. Thank you.
Important individuals. Would like to acknowledge the presence of the head of the Civil Service of Ghana, Nana Kwesi Ajiman Dramina. Let's give it up for him. Thank you so much, sir, for being with us this morning. Ajekum Dramina. Sorry about that. We'd like also to acknowledge the presence of Mr. Paul Effa, the president of Radford University. Also would like to acknowledge the presence of Dr. Esther Ofe Abuaji, a management consultant and a member of CIAMC Conference Advisory Board. Thank you so much for all the great work you've been doing. Would also like to acknowledge the presence of the Registrar of the University of Environmental and Sustainable Development Studies, Mrs. Mary Abena Ejapon. Thank you. All right. Our third speaker. He is a chartered professional administrator and a chartered management consultant. He is a prominent Ghanaian politician and lawyer. He is a member of the Council of State and a fellow of the Chartered Institute of Administrators and Management Consultants, Ghana. In 2011, he was chair of the International Advisory Commission of the Commonwealth Human Rights Initiative and a member of the Commonwealth Lawyers Association. He is a former member of Parliament in Ghana. During the Second Republic, he was one of the founders of the National Alliance of Liberals and was elected as a member of Parliament. He has served as chair of the Public Accounts Committee and president of the Ghana Bar Association. He has also served on the Legal Aid Committee, Prison Service Council, the General Legal Council, and the Judicial Council of Ghana. Ladies and gentlemen, with a round of applause, let's invite Honorable Sam Okujeto to the podium.
Madam Vice Chancellor and Chair of the meeting, Nana, Chair of the Board. Coincidentally, Nana was also my student. So I made him a lawyer. Distinguished ladies and distinguished gentlemen, I was requested to speak on the law of meetings. I don't know why, because I think I was bullying your chief executive, and I think that will give him the idea that perhaps we needed to discuss this topic. But my interest more was on the question about corporate governance, which I will advise that maybe another time we should look at that, because that's a broader subject, and the law of meeting is only a minute aspect of that subject. Now, when I started practice of law, I was very much interested in the Ghana Bar Association. And when we had meetings, I realized the mess that was happening. So I challenged the executive to say that they were not observing the law of meetings. And then they looked at me and said, "What is the law of meetings?" No, these are seasoned lawyers, mind you. So I had to explain to them that indeed companies are supposed to have company secretaries, but the company secretaries are trained for that purpose. And as part of their training, they had to learn to observe what we call the law of meetings. So in fact, meetings are governed by law, simpliciter. And what they did was, I think the following year or so, they elected me to become the secretary of the regional bar. So the critic should now go and be the one in charge, so that he no longer criticizes us. And so, because the assumption then was that because the person is a lawyer, he should know. And I said, no, that law is not taught for the qualification to become a lawyer. So it's a separate subject altogether. And in many instances, the person who has to do that has to be trained as a company secretary. And when he's trained as a company secretary, then he knows and he understands what the law of meetings is. So let's look now at this law of meetings. This is the synopsis of what I want to talk about, and maybe I may not take that long as the others have done. So we have to talk about the types of corporate meetings. And we look at the corporate governance rules, because this has emanated from some of the confusions that arose. A part of it, as I was talking about, is that when we start talking about corporate governance, you will see that that terminology itself came about in 2002, when the confusions arose in America in the famous called the Enron case. And that confusion brought about the disorganization of the whole financial system in the world. And companies went bankrupt. Many directors had to be jailed. And all that was because of lack of understanding of what we call governance in the proper sense of the word. So what then is the meeting that we are talking about? Meeting is a gathering of members of a company or the board of directors or relevant stakeholders who make decisions that govern the company. The company itself, we all know, is an artificial person. It can sue and be sued, but it's not a human being. And oftentimes you find out that it is those involved in it who form the company or described as done in the company. I may specify that a company is a limited company because it is registered under the company's code. But then that's not the only institution that has meetings. The University of Ghana has meetings. The council of the university has meetings. The committees of the council have meetings. The institution that is hosting us today has meetings. Professional groups and organizations have meetings, and all of them are governed by rules. But the issue for us to keep in mind is that the purpose of having rules is for the purposes of...
This is where I intervene as chair. There's a distraction. Where are technical people? Can we get that quickly off the screen?
The screen is not coming.
Our technical people, please, we need you.
But they're not watching. Somebody should have been watching to ensure that. I think it's blank. It's coming from here. One of you should have been watching the board all the time to ensure that. Sorry, it's not this. You can't use the cursory. As I was saying before the machine decided to interfere, I was saying that the company is an artificial person. And so normally we refer to company, but company is composed of the people who are involved in it. That has the meeting. And so when we start talking about meetings, let's just appreciate that we can talk about company meetings, we can talk about board meetings, and we can talk about institutional meetings by various institutions. Now, the rules that govern this will depend upon the law that makes the institution. For example, the University of Ghana is under the University of Ghana Act. All the various universities you have in the country, some statute or law. And it is that law that governs how the institution is meant to be run. So the company's code is only an impediment because limited liability companies are registered under the Companies Act. And therefore, that's the law that governs it. But in addition to that, there are specialized institutions as well. You will see that there are financial institutions which are under SEC. And so SEC make rules in addition to what the company's code contains. And all that will specify the meetings or the kind of meetings that can or ought to be held. I'm using those words advisedly. Because there are certain meetings which are compulsory. That's why I say ought. The law specify how they can be held, when they can be held, or even where they can be held. Because now we are all assumed that it's Zoom, isn't it? So everybody assumes that everything goes on by Zoom. But it's not that simple because there are certain things you cannot just do by Zoom. Because some of them require that someone should be able to sign the document. And where would that person be? And Nick, how do you even establish that? As to who and who participated in the meeting. So these are all complex matters and it's very important for us to have that in mind. So we have what we call general meetings. And these general meetings may be annual meetings. That is something which every company is by law obligated to hold. Not more than 15 months after 1 year. That means they are giving you a grace period because the year should have been 12 months. But they give you a grace period to say that within 15 months you must hold the annual general meeting. Then we have what they call extraordinary general meetings. They are extraordinary because they are specific. There may be a particular reason why that meeting should be held. There was a particular decision that needed to be taken. And that decision can only be taken at a meeting. And therefore, because it is not board of directors. And so they have what we call a board of directors meeting. Those are the people who take the principal decisions that governs the organization. There are many a time when the ordinary shareholder assume that, why are they doing this? What authority do they have to do? But they forget that the board is the manager. It's not the shareholder. The shareholders are not the managers. The board is the management, and it's the board that takes the decision. So the board takes the decision. The decisions are taken at board meetings. But the board also normally have committees, specialized committees, which deal with specific issues. And we will come to name some of those committees. Indeed, when you look at the corporate governance rules, it actually specifies some of the compulsory committees that the board must set up in order to discuss issues. There will be, let's say, a board committee on remuneration. And so it is not, as was being explained by Mr. Game to you, where we assume, everybody assumes that I'm a shareholder, isn't it? And therefore, this is what I'm entitled to. Well, it doesn't work that way. There must be who has the responsibility to do that. And it's easier to have committees that consider the issue and bring it eventually for the whole board to ratify. That's why we call them board committees. And I think the university, for example, you have a lot of committees that the board considers, because they can meet more frequently than having the whole of the council to meet or the whole of the board to meet. And that's why we have specific committee. And also they have more in-depth knowledge and time, because the board meetings, they are time conscious of it. The amount of time you can spend at board meetings is limited. But in committee meetings, you can do it and even adjourn and continue, because you want to get results, which then you can present. That's why it is useful to have board subcommittees of the board. Now, I'm jumping to talk about these corporate governance rules because they have become now the thing. It is so important. And so, in the Companies Act 2019, Act 992, there are rules which were laid down there. And then there is the Corporate Governance Manual for governing boards, councils of the Ghana Public Service. Your Public Service Director is here. And they made very elaborate rules to govern public institutions. Because don't forget, the public institutions are not set up under the Companies Code. And that is why they needed a separate rule to govern them and to ensure that they are done properly. Then the Securities and Exchange Commission also made a code on listed companies, which was made in 2020. Elaborate rules to govern corporate governance. And part of it contains the rules connected with meetings. That's the reason why I'm mentioning it. Then there is also the Corporate Governance and Directives 2018. This is issued by the Bank of Ghana for banks, savings and loans companies, finance houses, and financial holding companies. The reason for this is that the banks and the corporate institutions, they are sensitive institutions. They are dealing with money and people's money. And we remember the scandals that arose a few years back when some managing directors of banks were giving loans to themselves, to their families, to board members. And it crippled the whole of the economy of Ghana. That the government of Ghana has to go and spend billions to salvage those banks because rules were not being obeyed. And so when maybe someone is making a fuss and says that, but these people, who took the decision? How did the decision come about? Was the decision published? Was it filed with the registrar of companies or the registrar general? Was it filed with SEC? It is not that the person is being fussy. It is just because they wanted the right thing to do. Because when people have deposited their money at the bank, they want it to be what? Safe and protected. They are not dashing it. In fact, the confusion is that sometimes people even think that because I own the bank or I'm the major shareholder in the bank, I can do whatever I like with it by taking decisions. It's not true. The shareholder, they tell you the truth. If you check on how much the person has invested in the bank, it's quite a small amount of money. The rest of the money is whose? Who knows? It's the depositor's money. So the manager or the managing director or the board has no business trying to misuse the depositor's money. And these are the reasons why rules are important. And so now we come back to the meetings. So we talk about general meetings. This, as I say, must be held each year, and at least 15 months for limited liability companies. That is the longest that you can use. The state-owned corporations require that meetings be held quarterly, subject to the laws establishing the organization. That means there may be separate law that may specify other kinds of meeting. The meeting is chaired by the chairperson. Now, normally we talk about chairman of the board. Is that not right? Nana here, for example, he has the responsibility. He's the chairman of the board. But also another very important person in the meeting process is the secretary. There has been some misconception over the years where people think that anybody can be called to be secretary. And so sometimes you see company incorporated, you find out that you talk about the secretary, then they put a name there, a profession, you say housewife. And sometimes he's the child of the owner. His name is put down there as secretary, because they don't appreciate what the secretary's role is. Importantly, the secretary at board meetings must sit next to the board chairman. Why? Because he or she helps guide and direct the chairman as to the way the meeting should be conducted. The agenda is before him or her, and he's showing you what to do. And if there are rules that perhaps the chairman is not observing, the secretary cannot get up and speak and say. He whispers to the chairman and say, Mr. Chairman, sorry, this one is not allowed. Oh, there is this law that governs it. You are not observing it. Please, let's look at the law. Even where there is the need for legal counsel, it is the secretary who will try and suggest you and say, okay, this is my view on the matter. If you don't agree with me, we can get legal counsel who can advise us. Of course, the reason why he is aware of legal counsel is because he has knowledge of the law. He's not making a conjecture, no, because he knows that there must be. There is also the responsibility of the secretary to ensure that the decisions of the board are recorded and that they comply with the agenda. The agenda for the meeting must be complied with. You cannot call a meeting without having an agenda. And those who are calling to the meeting must be aware of the agenda for the meeting. Why? Because they must prepare. The agenda will enable them to prepare. so that they can make a meaningful contribution to the discourse that is taking place. So as I said, the business at the general meeting includes what? Number ratifying decisions or making recommendations to the board, approving major transactions, declaring dividends, and appointing or removing directors and auditors. This is the general meeting that these decisions are taken. But before the general meeting can proceed on that, they must have had knowledge prepared by who? The board. Now, there may be time where the directors see fit to convene another general meeting in the year, apart from the annual general meeting as we've spoken about, because there may be issues and problems. Company, for example, may be in difficulty where people have subscribed to shares, but you know that the shareholders do not necessarily always pay for their shares in full. Not necessarily. Depending upon when the shares were issued, they may be partly paid for. The company may be in difficulty and therefore needed to require that the shareholders be asked to pay for the balance of the shares. Or even they may fully have paid for it, but the shareholders, the directors may feel that they needed more funds because they wanted to undertake certain other projects which would be of benefit to the shareholders. In which case, they will call a special general meeting and put this proposition to the existing shareholders, and whether they will agree to subscribe to more shares, as the case may be, or go to the stock exchange to authorize the board to go to the stock exchange. So these are very, very important. Now, who then can call the meeting? It is the responsibility of the board, or more preferably to say the chairman, to call a board meeting. But there will also be the right of the shareholder to requisition. I'm using that word advisedly, to requisition. That means they will make a demand to the chairman for a meeting to be held. We were talking a few minutes ago about confusions in the banking system, not so. Many of the shareholders, they were lame. They were just sat down and their monies went away. But it would have been useful if they are aware. Two of them can requisition for a meeting to discuss the turbulence which was going on. Perhaps the crash that happened may have been averted if the shareholders were conversant with the rules. And so you will see why it is important for us to understand the law of meetings. Because when you are aware of it, you are managers, you are being trained as managers, you will know that when there's this problem, what do? You don't fold your arm. You don't go on radio and start gossiping. What do? You requisition for a meeting so that the issues can be discussed. And if you do your homework well, you would have marshaled enough of your members so that they can support you. Because sometimes chairmen can bulldoze their way very easily. And in the Aaron case, it was so serious because the chief executive was also the chairman. And since then, we have been advising that the CEO should not be the chairman of the board. That you need an independent person to be the chairman of the board. Because there can be conflict situations. And I will give you an example. I remember at one time, the IGP was also the chairman of the police council. We've changed the law now. Now he's the vice president. But at that time, that was what it was. So what happened? Officers make complaints, and the complaints go to the IGP, and what happened? The matter never comes to the council for discussion. And so when the CEO is misbehaving, or you think he's misbehaving, the proper thing to do is to do what? Appeal to the chair. Then the chair will either have to resolve the matter with the CEO, or alternatively bring it before the board for discussion. Not necessarily for chastisements, as some people assume. Because I think Mr. Game was telling us about this Joe business, the issue of having an opportunity where you can discuss issues. Perhaps there is an explanation. And if you allow the person to come, the person may come and explain, you may be satisfied that perhaps your perception was not correct. And so this is the whole basis for it. So meetings are for that purpose. Now we talk about the board meetings. As I said, the meeting of the board of directors is to discuss and make decisions for the board or for the governance of the institution. That is what it is all about. So the board normally acts by resolutions taken at board meetings. Now, what is the resolution? That is the decisions that they have come to. Because I have seen situations whereby somebody will come and say, oh, but at the meeting I said so and so and so, but it is not in the meeting. It's not in the minutes. And we say, what you have said is not relevant for the purpose. The meeting is supposed to record decisions. The meeting is not for everybody who speaks, that it might be put down in the minutes. Unless the person decided that what he or she is saying is so important that he wanted it to be recorded, then it has to be recorded. Otherwise, it is merely the decisions that go. So the decisions come in the form of resolutions. It is resolved that the company will float this so and so thousand more shares to enable it to be able to acquire this other business which will be useful for the shareholder. That's a resolution. And so once that is passed, every shareholder is bound by that resolution. Whether he or she was at the meeting, completely irrelevant. It is a decision by the company. And the board is the one that initiates that process by its own first discussing the issue and coming to a conclusion, and then put to the members in the special general meeting as the case may be. I have stated here that board meetings must be held at least once every 6 months. It's however encouraged to be held quarterly. There are issues that things are happening all the time. And for the safety of you, the managing director, the CEO, the vice chancellor, for your own safety, it's always important that you carry the board with you. And so when you have quarterly meetings, it is easier for people to prepare to come that meeting, marshal themselves with facts, informations, and the rest to guide the other members. That is why it's preferable to have quarterly meetings, except maybe there is an emergency that changes it. So the agenda for the meeting, the documents to be reviewed during the meeting, the minutes of the previous meeting must be sent to the directors before the meeting. You don't shuffle documents to people at meetings. They are supposed to study it. The minutes must be studied so that the person who has a query about something which he thought was not properly recorded can at the meeting bring it out so that it can be discussed. And so that is why it is very important that documents must be sent to those entitled to attend the meeting before the meeting. The rule, in fact, says that 20 companies could talk about 21 days. The rest may depend upon the constitution of the institution, as the case may be. I think I already referred to the fact that you may have subcommittee meetings. So the board may have subcommittees that handle various aspects of the work. The committee may be what they call standing committees or ad hoc. Ad hoc means that it is set up for a specific purpose, but the standing committees are permanent ones. As I said, I think I made reference to, let's say, remuneration committee earlier on, and there are so many of them that the corporate governance code actually specifies. And these are committees which are always functioning, and they help the administration to come to a proper decision. So under the corporate governance manual for Ghana, public service, and this is the precedence so far as our institution is concerned. This is the way it is done, and it helps order. I'm very crude about the question about order. I tell people that the first rule in heaven is order. Then I ask them whether they know what the second rule is, and of course they are anticipating something. I say it's also order. And the last and the third of the rules is also what? Order. So there is order in heaven, there must also be what? Order on earth. And you find out that when the institutions are obeying order, doing things orderly, things go smoothly. Somebody will come and you say, oh, as for our CEO, he stops. He stops. Why? Because he's observing order. As for our chairman, he's a no-nonsense man who, when you want to go to him, please marshal your facts properly, have your records, have your documents before you go to him, because he would have asked you, I said, where did you get that from? Who told you that? You can't say what the girls will say, ake. Eh? And Ghanaians love that, isn't it? That's not the way it works. There must be order in everything. You may think that you are going to finish the VC. So you marshal some people around you, you're making noise, and says, for this one, we are going to get her out. When you don't have anything to support it. If you have something to support it, what we should have done rather was to go to her, confront her with the document, say, this is what we have seen. VC, what's your reaction to it? Then they say, oh, that document you're holding in your hand, it's a forgery. Even the signature underneath it, which purports to be mine, is not me at all. You see, otherwise you would have gone to the press, not so. And when you go to the press, you know what she will do to you? She will sue the newspaper, sue the radio and television station, and sue you personally. Then you say it's a wicked woman. I mean, this is what I was told. And now you see she's taking me to court. What? You are told. Did you go to verify? You didn't. So I think as Mr. Game was emphasizing, this question about communication is so important. So important. And I told people that the reason why there are divorces is because of lack of communication or miscommunication. Because husband says one thing, right? The lady understands it in a different way altogether. But instead of asking the husband, is this what you mean? He said, oh, me? No. That's not what I mean at all. They say, oh, what do you mean? Then he explains it. You even feel ashamed that you raised it in the first place, but it was better that you raised it instead of making an assumption about that, because language is a problem. And also one thing I have realized is that it depends upon people's prejudices and biases. And that may emanate from some outside problem. Person is angry already with someone. And because he's angry with someone, a mild statement or even chastisement, You understand in a different way, then it flares up. When a calm, collected discussion would have resolved the matter. And so these things we are talking about now, about meetings, boards, the rest are based upon this. That things can be done to make institutions work smoothly, if only we will appreciate that dialogue is the criteria, means discussion, talking about issues, resolving issues. I mentioned already about the ad hoc committee because they are set up for specific purposes. Now, the most important thing about meeting, of course, is the fact that there must be notice given. And the notice must be in writing. That's the only thing you can call as proof, isn't it? It is proof that notice was given. You say, I didn't receive it. The question is that, what address did you give for the notice to be sent to you? If it is sent to you at the address that you have given, then it's your problem, not so. In fact, in the old day, we even assumed that because those things we used to have postal system, we would say that there is an assumption that 2 or 3 days after the postage of the notice, you are deemed to have received it. In other societies where there is delivery to your house, once there is a signature on the document to indicate that it was sent to the house and somebody in the house signed for it, you are deemed to have received it. And these days we are even using electronic system, which means that if you give an email address or a WhatsApp address and it was agreed that that is the means they should use to convey the notice for the meeting to you, and it is sent, then you are presumed to what? To have received it. As I say here, that must be given to the member or their legal representatives, directors, and the company's auditors. All this for company are the people you are supposed to send the notice to. And I have already indicated that at least 21 days notice period is required by the company's constitution. And the constitution of the institution may prescribe a longer period. But if no longer period is prescribed, then you must ensure that 21 days is adhered to. It must contain the date, the place, the time, and the nature of the business to be transacted at the meeting. Important, the date, the place, and the time and the nature of business to be transacted. The reason is simple. You may have a regular board meeting place, right? But something may happen. There could have been a rainstorm, isn't it? Which have soaked the conference room. And therefore you may decide that you want to have the meeting elsewhere, maybe in the same establishment, different room altogether. But that must all be indicated to the person. So the person does not come and start spending an hour around, walking around, trying to find where the meeting is. It's very, very important. So the business of the meeting must be in the notice. And if that business is not in the notice, then it cannot be transacted. Because I think Auntie Ivy will know that sometimes we say any other business. We love that word, any other business. To tell you the truth, any other business is no business. If the thing is important, then it should appear as part of the notice for the meeting. Perhaps any other business just means that an opportunity for us to brainstorm and find out what else there is for us to do. I think that, to me, is its meaning. It is not to introduce a new business altogether for discussion, because then you are depriving those who are supposed to be at the meeting but who are unable to come to the meeting who could have made a contribution on the issue, you are depriving them because they weren't aware. That's why it's important. Again, it's just part of the order that I'm talking about that makes the things more orderly. Now we come to the procedure at meetings. I think I already touched this already. So the people entitled to attend general meetings are the members. Members in this case means what? Shareholders. Or we have trust institutions also. They are members, but they are not shareholders because they are not supposed to hold shares. So they are members. They are the directors, the company secretary, and most importantly, the auditor of the company. Because since you are going to discuss financial matters, it's important for you to get the knowledge that is required. I would even say that if, for example, the issue you're going to talk about is, let's say, land matters, isn't it? Now we heard our lady expounding to us about the land issue. Is that not it? Then it will be useful for you to do what? You invite her. It may require a payment of some fee, but you cannot be penny wise, pound foolish. It is better you get the expert who can come and give you expert knowledge and pay a fee for it rather than to go and make a blunder, which then will cost you a lot. So for board meetings, the directors, the secretary, and any other executive who is required to give information must attend. I use the word any other executive, meaning that there are a lot of people in the company who are in charge of specific issues. And since you want to discuss issues which concern those issues, it is useful to do what? To bring them to the meeting so that they can be able to expatiate and explain and help you in taking a decision. You don't take the decision and then go and impose it upon them when they have no idea about the matter, when they could have assisted you in taking a better and proper decision. So any other person may attend the meeting with the permission of the chairperson. The chairperson is the most important person in that whole. So he will decide that maybe this person can come or need to be there. Then one of the most crucial issues which often around is that there must be a quorum. No meeting can take place if there is no quorum for the meeting. And what is a quorum? Quorum is just a number that will be adequate for the purposes of taking a decision. Many institutions specify the number in the constitution of the institution itself. Or normally we say that it is 50 plus 1. That is at least more than half. Otherwise, a handful of people can meet and take a decision which is binding on people who have no idea about it. That's why we say that there must always be a quorum for a meeting. And the quorum must be present at the beginning of the meeting. So no quorum, no business. But if, for example, as we are here, the quorum is there at the beginning, but somebody decides to go to the loo or go somewhere else when we all have pro time, then that one doesn't matter. It's only in Parliament that there is a different kind of rule. Actually, it's actually not different. You see, in Parliament, there must be a quorum when the sitting starts. But a lot of people register. Mr. Game, am I wrong? They will register for the meeting, and then they will pick their bag, and they are gone to go and do their own private business. So the meeting will go on, and they will take decisions. But the power that is given to individuals is for you to count the members in the House. And if you realize that a quorum is present, you raise a quorum with the Speaker. And then he has no choice but to count. And if he's counted and he found out that there was no quorum, meeting is adjourned. But so far as general meetings are concerned, as I said, if there's a quorum at the beginning, business can be transacted. If it's a board meeting, there's quorum at the beginning, business will be transacted. The business of the meeting stated in the notice must be followed. I think this one is very important. It must be followed. I'm not saying that necessarily in the order in which it is in. That can always be, the chairman can always say that, okay, we think that this one is important. We need this person's advice on the matter. He has another meeting he has to go to, so let's change the order and transact that one before he or she leaves. But it must be important to adhere to the order. So members must be given sufficient information on the voting rules and allowed to question the board and management. Again, we always say that for lack of knowledge, what happens? The people perish. And it's important that these rules are explained to the members. What we are going to vote for is a resolution to increase the shares of the company. It must be expanded and explained before you can put the resolution to the members to vote upon. Otherwise, and unfortunately also at most meetings you find out that people are spending more time conversing rather than listening to the chair. So they wouldn't even know what's going on. And it's very common in Ghana. And these days, our telephones have become the culprit, because we are here, we are doing WhatsApp, when in fact you are supposed to be in the class learning. As you know, correct? But we are all supposed to be learning here today, isn't it? But you can see people who are busy on their phones, and it's they will pretend as if they're actually recording or making notes. When in fact, when they go outside and you ask them, what happened to this man? They can't answer. I mean, as a teacher, there was one gimmick I used to play. I tell people that I use a scanner when I'm teaching, because I'm normally not doing what I'm doing now, but even here you can see that I'm looking up. I'm not necessarily at the screen all the time. So I'm scanning the room and I'm seeing those who are listening and those who are not paying attention. So my gimmick was that I'll say, Nana, what about this issue? And then you can see him struggling, because in me, he wasn't listening. And the question would be, somebody say, but how did you know? I said, well, because I was scanning the room to make sure that everybody is attentive. So, the chairperson, I'm coming back again to the chairperson. The chairperson conducts the meeting. He or she maintains order and ensures that proper procedure is followed. The chairperson of the board presides as chair of a general meeting as well, unless the company's constitution provides otherwise. I will even say that the company's constitution should not provide otherwise. It should always be the chairperson should be the chair. And if he is not available, they can elect another board member to chair the meeting. So the chairperson is guided, I said already, by the company secretary. I'm using the word guided advisedly. It's very important. You can even underline it if you like. That the secretary is there to do what? To guide, not to contradict, not to do anything else, but to guide the chairman in the conduct of the meeting. So that's why he said that you must sit beside the chairperson so as to guide him. He also is ensured that the minutes of the meeting are recorded. And so let's draw a distinction between a recorder of meetings and the secretary, because sometimes we confuse the two. The secretary can designate anybody else to be the recorder, but he or she has the ultimate responsibility for what's recorded. Very, very important. He's answerable for it. And so now I'm talking about the minutes now. The minutes are written records of everything that happened at the meeting. Caution. I'm not saying that any kind of nonsense that happened, the meeting should be recorded. Because I'm also aware of people who love to talk or pretend to be knowledgeable. So at every meeting that they will put up their hand to go. And then sometimes I have to say the chairman should be discerning. When you know the talkative people who will just take time and blah, 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 you ignore them when they put up their hand. You can even say that, okay, we limit the thing because we have not much time. So I'm giving all of you just 5 minutes, no more. You can make your intervention or suggestion or whatever you want to put across. So that's the chairman's responsibility. So the minutes must be entered into a minutes book, which is kept at the company's registry or registered office, and it's available for inspection. Any member can go there and inspect it. Even if it demands a copy, he may pay for it, but he's entitled to have a copy of the minutes which are entered in the book. I'll tell you a story about minutes book. I was on the Bank of Ghana board. Then Atta Mills came into office as president. Then he announced that all boards dissolved. So I wrote to him and I said, you cannot dissolve all boards. I am on the Bank of Ghana board. I have 3-year terms. And I have, Kufuor was then president, so I was appointed thrice. On my 3rd term, Atta Mills came into office. So I wrote to him and I said, you cannot dissolve the board because I am appointed under the law. Then he ignored me. So I said I was going to show this young man. He's much younger than me. Show him something. And indeed, it was very funny because the bar used to organize educational seminars. And at one time, he and I were together. He lectured on company law, and I lectured on company practice. So we were quite close. And he ignored the letter, so I sued him. And so they were playing games, they were like John and all kind of game. I was laughing. I said, it doesn't matter how long you play your game, we will be on. So eventually, the case went to the court. The case was called. They brought somebody from the Council of State to say that there was no record that I was appointed. So I sat down and I was laughing. My partner was the one conducting the case, but I was the one briefing him on the issue. My partner became Supreme Court Judge, Nene Amagache. So I was there, I was laughing, and I said, this idiot, he doesn't understand that this is a subject of which I am an expert at. So I said, ask him, where did he get that document he got from? He said, oh, he took it from some files on the pillar there. Who signed it? Oh, there was no signature under the paper. I said, so how can we be sure that this thing is authentic? Oh, no, I got you from so and so and so. I said, all right. Then I saw one of the papers that he brought. There was a discussion at the council raised by Mr. A.K. Daku that they should file the thing, they should buy a minutes book to make sure that the documents are filed in the thing. So they asked him, did you read Mr. Daku's so and so and so and so? So where was the book that Mr. Daku said you should file the minutes in? The man was stuck. He couldn't answer. He was lucky because I should have had him to be charged for contempt and jailed so that he can learn some lesson. So I'm using this just as an example to tell you the importance of the minutes book. And so now the rule is that the minutes must be put in a permanent form. And that is why we have a minutes book. That is not a substitute for your electronic things that you are talking about. Because people now will say that we have an electronic copy. Not so. But we all know that electronic copy can be changed. Is that not correct? It can easily be changed. So that's not that's a minutes book is so important. So minutes must be recorded and put in the minutes book. And if there are several pages, then the importance is that the chairman signs on each page. It is just to prevent the process of someone going to produce another document pretending that it is the minutes of the book. It's so important. And indeed, it's good for the board and protection, because normally when they sue the company, you find out that that's your defense. The CEO is being accused, isn't he, of taking a decision or mismanaging and the rest of them. And CEO brings the minutes book and he says, the decisions I've taken were what the board authorized me to take. So how can you accuse me? He's won his case. So very, very important for us to keep in mind that minutes book are very, very important. So we say here that it serves as sufficient evidence of the proceedings of that meeting. The minutes book serves as evidence of the proceedings of that meeting. It's authentic. You cannot be contradicted. So now I came to the topic about resolution. I thought I would have finished long by now, but I'm going longer than I thought. But I hope you are bearing with me, because to me, this is so important for all of you as administrators. So a written document created at general or board meetings is described as a major corporate decision of the board. That's what you call a resolution. So the type of resolution are what we call ordinary resolution, which is made by a simple majority of votes. That means you just put the issue and say, okay, those in favor, those against, we count, those in favor win. In Parliament, they go by voice vote. They say those in favor, then some people increase their volume, louder. But then the speaker has all the power. He can declare in the end that it is the years have it. But then you see there's another gimme you can also play on him. You ask for a recount, in which case it has to be individually. That's a trump card that you have. But normally, for purposes of decorum, they use the voice vote, but not at a meeting of companies. We do that by raising of hands. Special resolutions made by a 2/3. That if it's a special resolution, then you require 2/3. As I said, if you are saying you are going to increase shares or undertake a major project, then it's important that the majority of the members should support it. So ordinary resolutions are usually taken to decide on the normal business transacted at meetings. But special resolutions, they specify law or in the company or the constitution of the company. Some instances will go where a major transaction is to be decided. I think I've said that already. It's a major decision, a major transaction that they wanted to take. Maybe they want to acquire another company, in which case it's important. And I think the university, you're getting into trouble about whether you have a new course or program, isn't it? They're threatening you now. It's important and it is done, so there's no problem. Because litigation is an expensive process, and oftentimes it retards the progress of an institution. And sometimes when I say it as a lawyer, they say, but if you are saying that, then it means you know and you're living. I said, no, you're getting it wrong. We don't like chaos. We can help to resolve matters. Mr. Game is an arbitrator. Yeah? He's helping to resolve issues. ADR has become a potter. Lawyers are practicing. Some of the lawyers that's all they are practicing. They are not doing anything else. They don't go to court. And yet, they may be the one who are more wealthy than those who go to court. In fact, my joke used to be that if you are seeing the person in court every day, you might know that he's poor. Because I don't see how much money he can make by appearing in court every day. The reason is that we unfortunately are not paid according to time. It's on this, the constitution of the bar prescribed fees process, and people assume that way. I say, listen, that's only a guide. It does not work at all. So that is not the issue. We prefer to have the matters resolved. So special resolutions must be filed at the office of the Registrar of Companies within 21 days of it being passed. The question is that anyone dealing with a company will know whether you are authorized to do what you purport to do or you want to do. And where does he get that information from? He goes to the Registrar of Companies to check and see whether a resolution has been passed that way, which authorizes the company to do what it says he wanted to do. So that is the reason why this is specified in the law. There is something else we call written resolutions. These are decisions which are taken not at meetings. Because sometimes, you have company where you have members